I want to welcome to the program Sarah Miller. She's the executive director and founder of the American Economic Liberties Project. Sarah, welcome to the program.
Hi, thanks for having me.
So, Lena Khan has been very busy over the past couple of days in particular, but I mean, really, since she's been the chair of the FTC, there's two things I want to talk to you about. One is it is a proposed ban on non-compete agreements. My understanding is there is now the comment period has started. It is about probably, I think we got 58 more days or something like that, maybe 57, where people can comment on this proposed rule. It was voted on 3-1 to get to this stage where they will take the comments from the public. Give us some background on this proposed ban.
Great. So non-competes affect roughly 1 in 5 workers in the country. That's around 30 million people. They affect high-income workers like executives. There's a very high prevalence of their use among kind of that cohort of the workforce. But they're, from a numbers perspective, they affect more kind of mid-wage and hourly workers, janitors, security guards, hairstylists, fitness instructors, nurses and doctors and veterinarians and journalists. They are just really a pretty staple feature of employment contracts at this point and have really been popularized over the last 20 or so years. So a number of states have kind of stepped up to try to regulate the use of these non-compete agreements. But what the FTC is proposing is a complete ban on including these agreements in employment contracts. And then they're also kind of going even further and looking at sort of implicit ways that employers tend to try to tie workers to their jobs, like through things like training repayment, agreement provisions or traps, which require you to pay your employer training costs if you leave to take a new job. And there's a whole lot of worker harms directly that result from non-compete agreements, and then broader economic harms, which we should dive into.
Let's dive into, those. We know about, talk about wage suppression, but it goes beyond that.
Yeah, the FTC's economists found this kind of staggering figure that there's an annual kind of decrease in workers' wages by roughly $300 billion. So that's a 3 to 4% difference than
annually
an economy in which, yes.
Sorry.
So these are not small numbers that we're talking about here. This is a major kind of systemic, systemic kind of counter pressure on workers' wages in this country, right? And so I think there's an impact both on your paycheck, right? Not only for workers that are subject for non-competes, but from workers that are locked out of competing for positions in a more kind of robust labor market, right? So it doesn't only affect workers who are bound by these, but it affects the labor market as a whole. It affects your ability to go start a new business if you have an idea. These non-competes prevent you from starting a competing firm. So that depresses innovation, it depresses economic dynamism, it depresses job creation because startups and smaller firms are such a crucial part of the job creation machine. And it hurts employers in lots of ways too. If you're an employer, you want to be able to compete for the workers that are right for you. And this kind of locks people into certain jobs and really gums up the labor market. So, I think good for Lena Khan for seeing that this is a practice that has both implications for individual freedom and well-being, but also has systemic economic implications that are really harmful both for the labor market and for the economy on the whole.
Well, you mentioned like the fact that white collar workers will get non-compete clauses, right? And that's, I think, what most people associate non-competes with. But some of the examples of, you said 1 in every 5 workers, that's just a staggering figure, right? Some of the examples of people who will be forced to sign non-competes are, say, if you're working at Jimmy John's, right? And they don't want you to go and work at Subway or something like that.
Exactly.
These go all the way down to minimum wage jobs, and that's really where it's most harmful, frankly.
Yeah, I think it's harmful across the board. Certainly, there's an impact in the healthcare sector when you have doctors locked into jobs and you have exploding healthcare costs. So I think that's an important thing to keep in mind. But you see some of the most marginalized workers, like Jimmy John's employees, and Jimmy John's use of non-competes and the lawsuit that I think the New York AG brought back in 2014 sort of put this on the map in the first place as a really pervasive and abused part of the employment kind of landscape. It is exactly right. So I think this looks at this practice. It looks at the authority. The FTC looks at the authority that it's been given to prohibit unfair methods of competition, and it seems pretty clear that they have the authority to promulgate this rule.
So they've put it up for comment, 60 days. Then they revote after 60 days, and let's presume that the majority of comments they don't have to follow the comments. They're not, this is not a vote, but not a plebiscite, but this is, a way to get different ideas. And so they can have different perspectives. It's also statutorily mandated that they do this when they're promulgating a regulation. But let's assume that 60-day passes, they have another vote, they pass this. Does it go right into effect? Because I got all these guys locked up on the show, and I don't want them going around to some other, what happens? Do all of a sudden?
I probably shouldn't give you legal advice, Sam.
I understand. All right, we don't have to make it specific to me, but what happens is the extensive contracts I have with everybody here, are they basically just void, and the next day they can go somewhere?
Yeah, so there's two ways to think about this. So I think if you want to look at it from kind of a formal legal standpoint, the FTC will put out a final rule at some point after they've reviewed the comments and made any revisions. And then that rule will have 180 days to take effect. So firms will have 180 days to comply. That said, the FTC has actually started enforcing against this already. And last week, they sued 3 companies. One was a security guard company who had particularly abusive non-competes in their employment contracts. So they're already sending a signal to employers that we're really going to focus on this, and you might want to get ahead of it. So I think we'll also start to see businesses kind of just proactively say, you know what, it's not worth it. While kind of the largest employers, your Chamber of Commerce's and really big trade associations are going to fight this tooth and nail.
Let's talk about Section 5, because one of the things that is one of the implications of this is that it's supposedly going to revive Section 5. What is Section 5? Why has it been dormant? What are the implications of it being revived?
Yeah, so Section 5 of the FTC Act grants the FTC the authority to prohibit unfair methods of competition. Historically, over the last 40 years in particular, the FTC has had a very kind of narrow view of what its role is. And there's been a lot of debate and conversation about that, as I think policymakers and the general public have become more aware of the kind of severe consequences of corporate concentration all across the economy. So this is coming in the broader political context that centers kind of the need to attack monopoly power and to approach this from a variety of ways in the kind of political discourse. So, the FTC has pretty wide authority under that statute to define and determine unfair methods of competition. And I think when you look at kind of the systemic harms of non-competes, when you look just practically at the fairness of something like a non-compete, it's kind of all in the name here. It's pretty straightforward. The FTC is on really solid ground, both from a policy and a legal perspective, in pursuing this rulemaking.
We hope, right? I mean, the Supreme Court, and we should say, we've talked about this on this program many, many times in the past, but the shift in essentially the government and the sort of the institutions surrounding this, both the sort of the antitrust bar and everyone shifted in the Reagan years, basically spearheaded by Robert Bork and the sort of the University of Chicago perspective on what antitrust was about. It moved from one that dealt with all of the implications of having trusts and monopolies in terms of what it meant for competition, broadly speaking, and political power and fairness. And it just shifted down to this very narrow perspective of what theoretically makes it cheaper for the consumer. And we tried that. It didn't work out very well. And so we're seeing this pushback. But the Supreme Court, they have not gotten this memo, or to the extent that they have, they've disregarded it. There was a case last year where, or maybe it was in 2021, where they started to inhibit the power of the FTC in terms of getting the way they would find remuneration for these violations. Can you just talk about that? And because this proposed rule, if in the event that it becomes a rule, which it looks like it will, could very well end up in front of the court, which I think is, relatively speaking, well, I mean, it's the same. It's the same 6-3 court.
Right. I think one of the interesting things to note about both the Department of Justice's kind of antitrust litigation strategy and the FTC's is they're very cognizant of the need to expand the boundaries of antitrust law from this very narrow set of interpretation that judges have kind of built into the case law over the years. The DOJ just won a kind of case against two large publishing companies that they argued on behalf of the labor market and the impact that it would have on the labor market. So what we're seeing, I think, is a slow and an inconsistent shift in the judiciary around how they're interpreting and deciding antitrust cases that touch on different kind of areas under the agency's jurisdiction. Obviously, I think the Supreme Court has proven to be fairly hostile to the administrative state in many cases. The politics around the non-compete rule in particular, I think are very interesting. We saw Republicans step up and support this ban. We've seen Republicans work with Democrats on bans that would apply to lower income workers. And in general, the politics around antitrust have been very scrambled and often bipartisan in surprising ways. So there's real kind of debates happening in corners that you wouldn't expect. Last month, Jonathan Cantor, who's the head of antitrust at the DOJ, gave a long talk at the Federalist Society of all places. So while, I kind of hesitate to predict a Supreme Court decision that, might come down the line, I think this presents a really important and galvanizing political fight. And, we're trying to encourage as many people as possible to weigh in and kind of share their stories through the comment process. I think that will be really important.
So let's move to the second big news of, I don't know, the week, or at least of the new year. The FTC is now investigating, or there's a preliminary investigation of Coke and Pepsi relative to something called price discrimination, which it runs afoul of the Robinson-Patman Act, which when I read that, I thought Matt Stoller, who I know also works at the American Economics Liberties Project, was, couldn't have had probably a bigger smile on his face on that day. Everything I know about Patman, I know from reading his book. Explain to us what this is and what the implications of this is, and what the implications of reviving the Robinson-Patman Act. I mean, the interesting thing about this is that for years, going back to 2014, 2015, maybe even earlier, when there was this sort of nascent revival, which I know you were a part of at a different outfit, a nascent revival of antitrust. And I would interview people about it, and everyone was saying, like, we don't need to pass any new laws. It is really just basically all these tools are there. It's just that people have to decide that they're going to use a hammer again as a hammer instead of, like, I don't know, a paperweight or,
I've heard about
a
this.
door, like a way to keep a door open. And that seems like it's happening now with this administration. Tell us about this price discrimination investigation and the Robinson-Patman Act.
Yeah, I will. Non-competes are pretty straightforward and simple. Robinson-Patman Act is a little bit more complicated. So earlier, or I guess towards the middle of last year, the FTC took its first step to start reinvigorating the Robinson-Patman Act, and they looked at pharmacy benefit managers. So they looked at drug prices. The Robinson-Patman Act prohibits not only price discrimination, but also commercial bribery. And so the fee structure between drug manufacturers and pharmacy benefit managers potentially, and this is something the FTC is investigating, is in violation of the Robinson-Patman Act and its prohibition on commercial bribery, right, which they call rebates or fees, right, but it's essentially result in illegal kickbacks and things of that nature. So that was the first kind of time that the Robinson-Patman Act was kind of revived in pursuit of the FTC's mission, and that was that was unanimously approved, actually, which was quite remarkable for a law that's been dormant for the better part of 40 years. The reporting yesterday, which I don't think has been confirmed by the FTC, but certainly has been a main focus of one of the FTC's Democratic commissioners, Alvaro Bedoya, would look at price discrimination in the beverage market, so Coke and Pepsi. Part of the reason why Robinson-Patman was not enforced is because there was a belief that large kind of chain stores like your Walmarts were more efficient, and it was kind of a values choice, right? We want to kind of centralize commerce. That was essentially what's happened. You see Walmart, you see Target, you see Amazon, right? These big centralized retailers, and that smaller stores are not efficient, right? And so the way that the larger chain stores help us kind of centralize their power or exercise their market power is by extracting lower prices from wholesalers that smaller firms can't get because they lack the bargaining power. So for Robinson-Patman essentially made that illegal and said, if you're a wholesaler, you have to sell your carton of orange juice to Walmart at the same price that you sell your carton of orange juice to Bob's Groceries down the street. And so because of that, the failure of that enforcement, I think the downstream effects are things like food deserts, are things like higher prices, maybe ironically, or what, certain people might argue with that. But across the board, you see, more market power among your Walmarts and, smaller retailers kind of forced to price very high to compensate for the price that they get. So, I think this is an area that's really, really important and that has downstream effects on everyday people, whether it's because you don't have a grocery store in your neighborhood anymore, or because you're paying, which obviously millions of Americans are, unconscionably high prices for insulin that the Robinson-Patman Act has a direct bearing on.
It must also impact wages again, too, in terms of like disempowering workers, because if, I am making it cheaper for Walmart to sell my orange juice, that is going to eliminate the competition down the road from Bob's supermarket. And if Bob and Walmart aren't, trying to vie for the same employees, Walmart has a monopsony there and has the ability to drive down wages in that community. Absolutely.
I think the knock-on effects of the level of market power that in the case of your Walmarts and your retailers was allowed to accumulate is quite broad. And it's something I think we're still trying to fully understand.
Let me ask you this too. Is this, and I know they haven't confirmed that they're doing it, but is this a backdoor way into which to deal with Amazon? Because it seems to me that nobody has, there's a multitude of other things that I think are problematic about Amazon, but one of those areas is both price discrimination and I would imagine also even just sort of like, I don't know what the word for it is, supply discrimination. I just remember during the, I've mentioned this story a couple of times, but during in the wake of the pandemic, local bike store was like, I can't get a hold of these type of tires. But I go on Amazon and they're there. My wholesaler can't get them. And then I just put in there, like, can I order 60 of these from Amazon? And they seem to have cornered the market because they use their buying power to do that. We're not going to take your 10 or 15 or 20 of these rare tires. And if we don't, you're going to be stuck with them. We're going to take all 60 of them so no one else can sell them.
Absolutely. I mean, anecdotally, we heard about this happening in a number of different industries where smaller retailers and smaller companies couldn't access supply, and contracts essentially weren't honored because larger firms were able to secure that supply, even if, there were contracts on the books with other firms. So that is a different kind of manifestation of the, buyer power that Robinson-Patman seeks to address and seeks to help constrain. I think one of the examples of how this power has been abused comes from Amazon. It's when they acquired diapers.com by simply underpricing diapers. So they lost money on their diaper business until diapers.com was faced with a choice. We sell to Amazon, we let Amazon acquire us, or we're going to go out of business. And under kind of the Robinson-Patman Act legal regime that's currently in place, that was deemed legal. I think there's a real question as to whether that sort of predatory and abusive behavior that kind of forces a business to either sell or die should continue to go unenforced.
Well, Sarah Miller, Executive Director and founder of the American Economic Liberties Project. I imagine we're going to be talking to you more over the next couple of years, because I think the most interesting stuff that's going to be happening in this during this the next 2 years is going to be coming out of the FTC and probably the DOJ in terms of antitrust. Really appreciate your time today.
Thanks for having me.
Thanks so much.